Hello everyone, it's Wayne Jones, the course coordinator for statutory interpretation at Central Queensland University. This week we're looking at presumptions, and it's in week 10, so it's chapter 10 of the textbook, which is Statutory Interpretation by Michelle Sanson. Very interesting area, and an interesting area in this sense that it's similar to last week where we were looking at the traditional common law approaches, and we decided that common law still had a place to play, had a role to play, I should say, in statutory interpretation, and it still had a place in sorting out issues and problems. And this is another version of what we were on about last week. So this is where the courts have been quite happy to determine over the years that you can make certain presumptions in drafting. Your text makes the point, I think, quite reasonably, that in doing that, the drafters of legislation are one step ahead of us, and they're assuming that the courts will make these sorts of presumptions as well. But bear in mind, here's a pretty illustration of some marker buoys, channel buoys and whatever, to make the point that they're really no more than aids. They really are no more than guidelines. I know that last week we talked about certain statutory rules. Same sort of thing applies here. These presumptions are not hard and fast rules, and they're just here for the assistance of the court in trying to determine the correct meaning of words. So part of the common law, as I said, and work hand in hand with the statutory provisions that we've looked at the beginning of the course. The presumptions themselves, and there are a number of them. I'm not going to labour them. I'd like you to have a read for yourself and have a look at some of the cases, but these are some of the standout things. First of all, they don't stand up in the face of clear words, so there's no hierarchy where statutory presumptions sit at the top. They just don't stand in the face of clear words. They vary in strength. Some are on the way in and some are on the way out, and I'll comment about my view about whether they're on the way in or on the way out as we go through and look at them. We looked at a case the other week called Coco and the Crown. This was the one where the police were looking for evidence, and they went on to a person's property in circumstances that would otherwise amount to a trespass, and planted a search warrant. The judge made these observations in the course of that court case. The court said this, that statutory presumptions can be displaced where there are clear words used. And so they call that the clear statement principle. So you've got clear words telling the court, don't apply that statutory presumption. But interestingly, in Coco, the court also said, you can also include where there's a pretty clear implication that the statutory presumptions aren't to be used. So you can either use clear words or a very, very clear implication not to use these presumptions that we're about to have a look at. Chief Justice Gleeson said in this case of Wilson and Andersen that there are presumptions which may be called into aid to resolve uncertainty. And I've put the helmet up there to remind us, again, just part of the toolbox, part of the kit of things that judges can use. It's just another one of those sorts of things. So that's how you should look at statutory presumptions, part of the tools available in the judge's toolkit. All right, now the first of them. This is probably an important one that I think is still reasonably healthy and well. Legislation doesn't operate retrospectively. In the absence of express words to the contrary, laws start on this day and they operate going forward. They don't operate backwards. There can be retrospective laws made, though, for the good. And remember this case of Re Wakeham. It was necessary to make a law to validate 12 years of court decisions after a jurisdictional stumble left one of the courts without jurisdiction. So the Commonwealth Government simply passed a law that said, we're not going to reopen 12 years worth of court cases. We'll just say that all of those decisions are valid. It can be for the not so good. Those of you who remember the Tampa case, have a look at it and think about, if you want to read any more about it, there's a great book out there called Dark Victory. But essentially what happened was a whole lot of different laws were broken in the way these people were dealt with, and potentially leaving the Commonwealth open for all sorts of claims, although hard to imagine people in the state that they were in making such claims against the Commonwealth government, but nevertheless some sort of show of force by the Howard government at the time, and they very quickly, with the agreement of the Labor leader at the time, Kim Beazley, signed off on this Border Protection Validation and Enforcement Powers Act. Look, it's probably bad enough that I give you a copy of it, so I'm going to put a copy up on the site for you to have a look at, and you make up your own mind. But even in the preamble there, in the long heading at the beginning there, an act to validate the actions of the Commonwealth and others, so specifically border protection people, Navy, SAS, etc., in relation to the motor vessel Tampa. So I'll leave that one be, but have a look at that when you get a chance. The other thing about this issue of retrospectivity, so we talked about retrospective for good, retrospective for not so good. There are opportunities for the court to make changes to the law which can have a retrospective effect. And we looked at the case previously of Rodway and the Crown, where the person was essentially deprived of a better case, so his prospects would have been better if the evidence of the underaged young girl in this sex case could be excluded. Previously that was the case. If it was uncorroborated, that evidence might not be allowed in. Now it was allowed in, provided the judge gave us sufficient warning. And so Rodway is about retrospectivity and working out whether it's what type of law it is. So there's no presumption against retrospectivity in the case of statutes which affect mere matters of procedure. So to give an example, if you're involved in a car crash 3 years ago and you go to court today, you are subject to all of the rules of evidence as they stand today. You're subject to all of the rules about all of the procedural rules about how to put your case in, how to file your documents, etc. All of those rules. But that was contrasted by, in your textbook, with Maxwell and Murphy, another case that we have looked at previously, where the case was really all about the time limits, and where a time limit had now expired due to a change in the law. And the court in that case said, well, although it's really related to procedure, it's still a pretty substantive matter, because it's a statute which, in this case, creates, if you like, or recreates a right which had expired. The time limit, the statutory time limit had come and gone, but this new statute potentially reinvigorated that, so it created, modified, or abolished a substantive right. But a statute that just dealt with the pursuit of remedies, no, it's not going to be the subject of the retrospective rule. Statutes which just deal with how you bring your action to court are not subject to this presumption, and they do apply. There's some legislation on it. Here's the Queensland version, the Statutory Instruments Act, that says if something's a beneficial provision, it can be given retrospective operation. All the Parliament has to do is say so. Alright, now the next of these presumptions, these statutory interpretation presumptions, is that the law doesn't have extraterritorial effect. So essentially what we're saying is that laws that are made in Australia just affect Australia. And that's usually the case, because although it's not mentioned in the textbook, it is usually the case that the court takes that view because it's not in a position to enforce its own judgment. So if it made some judgment about property, for example, in India, an Australian court's going to struggle to enforce that decision in another country. But nevertheless, the presumption that legislation only applies within Australia and doesn't have extraterritorial effect can be rebutted by express words, particularly where the operation of the legislation would be rendered ineffective otherwise. And there are some examples given in the text, including the example about the Crimes Act, where the legislation does go beyond the state of New South Wales. This is a New South Wales Act, by the way. Does go beyond the territorial limits of the state if there's some sort of a nexus between what's happening and, say, property in another state. The Commonwealth Act says this, and I think we've touched on this one before, that references to things in Commonwealth laws mean within the Commonwealth, so within this jurisdiction. Have a look at that section, section 21. Some great case examples. I won't bore you with the details, but do have a look at both of these, Polides in the Commonwealth and the Maritime Union case. In the Polides case, he was a Greek national in Australia, but was still subject to Australian law, which included the obligation to undertake national service. And in the Maritime Union case, the Workplace Relations Act was found to have application outside of Australia, particularly in relation to sailors on ships. Another presumption, this one that legislation doesn't take away the jurisdiction of the court. This one is still very strong for these reasons, that it's fundamental to the rule of law, that people can get access to the courts, and that providing access to the courts is one of the fundamental functions of government. So this one is not going away anytime soon. It's still very strong. The exceptions to this are that it's okay to insist that people have arbitration first. So it is possible to say you can't have access to the court until you try some arbitration. Now, another, legislation doesn't bind the Crown. Why would that be the case? This one, I think, is on the way down. This one's probably on the way out. It relates back to the separation of powers. So you've got the legislative arm trying to tell the administrative arm what to do. You should look for a specific reference in the Act, and in Queensland you have to see this in the Act. This Act shall bind the Crown, because essentially that means that the Governor has signed off on that law, saying that, okay, well, I agree that the executive arm shall be bound by this law when the bill is signed into law. Now, interesting point that's made, though, by the textbook authors, Brofo against Western Australia, that this has been stretched out a little bit. So although there was nothing specific in the Act that used those words I mentioned before, this Act shall bind the Crown, although there was nothing in there, the court still found that there could be a time when context and purpose would override that presumption, regardless of whether the express words were used. And they were quite happy to find that the legislation in question did in fact bind the Crown. Another presumption, I should say, that that legislation approves the common law. I think this one is still alive as well. Again, though, subject to the new rules of statutory interpretation, or the modern rules, if we call them that. The reason I say this one is still alive is that it's part of context. So that legislation approves what the common law has been doing is part of the context. And the textbook authors gave you a great example in industrial dispute. Defined once in a court case, Parliament uses exactly the same words. The court says, well, they knew the meaning, or they're taken to have known the meaning of industrial dispute in accordance with that fairly high-profile case, so we're going to assume that that's what they meant. This one, I think, also is still pretty strongly alive and well, penal provisions strictly construed. And that's because, essentially, the whole of the resources of the state are brought to bear on the individual. So it just, from a matter of fairness and justice, would seem that if A, the government can't get the legislation right and tight, and B, they still can't get a prosecution with all of their resources, then the benefit of the doubt should go to the accused person. In this case of George against Rocket, I like this phrase: to insist on strict compliance with the statutory conditions governing the issue of a search warrant is simply to give effect to the purpose of the legislation. So, I don't know, I think it's a bit cute. You might have a different view, but what the judges seem to me to be saying is we're still happy with this statutory presumption that penal provisions are strictly construed, but we're just going to put a twist of purpose or purposive approach into our reasons by saying, oh, well, the reasons that we're finding that strict compliance is required is because that's what the purpose of the legislation demands. But you could take another view and say, I think they found that the penal provision presumption was still alive and well. Almost missed one then. The opposite of that, of course, is that remedial provisions are broadly construed. So that's provisions where people have an entitlement to social welfare, pension benefits, occupational health and safety, workers' comp. There's a tendency towards the greater benefit to the individual. So not construed, if you wanted to reverse the terminology that we used for penal provisions, they are not so strictly construed. They're construed so that the person gets the benefit. And I think that one is still alive and well also. And the final, of course, from the famous Castle case, legislation doesn't usually intend to remove property rights. Have a look at the couple of cases that are in here. See if you can find some parallels with that wonderful movie. Essentially, the cases that the authors give you are those where a statutory authority like a council is wanting to take property, acquire property on what they say is just terms. Where the courts have tended to overturn the legislation is where it's clear that they are going to not only pursue their purposes, but they might also be making a profit. And I think in one of the cases at least, the intention was to sell part of the property that they acquired back to a developer. So look at those, I think they're really interesting. Next week we're going to take this further. So we've looked at the relationship with common law. This week we're still in the common law area by considering statutory presumptions. And next week, really interestingly, we're going to look at some fundamental and human rights presumptions that the judges can make when they determine the meaning of statutes. And so that's probably the pointy end of where we were getting to this week with these statutory presumptions. Look, I hope you enjoy the reading. I think it's quite an interesting little area. As usual, keep in contact with each other and come back to me if you have any questions at all. I'll be in touch with you again next week. Thank you for listening.